Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Hi, welcome to Inheritance Solutions for a Diverse Community with Richard Hall, founder of Bottom Line Lawyers. I'm Matt Skye. Richard combines extensive legal and real estate expertise to help clients with real estate planning and to protect their families' futures. Richard, thanks for joining us.
Thanks so very much, Matt.
All right, so let's jump right in. So you have extensive experience in real estate law. Can you share some of the common insights and challenges families face when it comes to real estate planning?
Sure. Probably the most common things that I see are in the situation with a blended family or a same-sex relationship. Each of those require custom drafting to make sure the actual wishes of the trustors, that is the people who are making the trust, are actually implemented properly and can't be undercut by subsequent actions by other people. In the context of a blended family, for instance, you don't want a surviving spouse to be able to cut out the children of the deceased spouse. Or in the case of same-sex relationship, you don't want a power of attorney changing the trust so that the life partner, same-sex partner, is cut out of the trust. Those things happen with some degree of frequency, and it's actually part of what motivated me to take on a focus for LGBT clients in the trust area.
Now, it's definitely a very unique specialization. What inspired you to blend your legal expertise and then you have this real estate broker expertise in California? So how does that provide a unique value to your clients coming from both worlds?
For so many people, their estate consists primarily of real estate, whether it's their home or rental properties or other properties. And so how properties are deeded, how they're transferred, the impact on assessments, all those things are really important when you're handling real estate. You need to make sure you do the things that dot your I's and cross your T's so that you're not triggering some taxable event or some reassessment event, and that you're not creating an opportunity for somebody to drive a Mack truck through your trust at some point.
Right. How often do you see people making mistakes when they're not working with someone like you? Is it pretty frequent?
Unfortunately, it is pretty frequent. I actually had a client who recently asked me what I thought about, I won't tell you the exact name, but one of the online services. And I said, oh, I love them because I get so much business out of that because people mess up their trust. And this is an area where do-it-yourself is not a good idea. I wouldn't do my own brain surgery. I don't think people should do their own estate planning either. It's extremely problematic because it's a very complicated area and there's a lot of things to think about. And that is one of the things I pride myself on, in thinking about the sort of the holistic picture of everything that's involved when you're creating or thinking about creating your trust.
Oh, it seems like you're able to go well beyond the boilerplate type stuff, right? I mean, people have these contracts drafted and maybe don't always think about all the details, but coming both from a legal and actually knowing the inner workings of real estate, it's a much more intricate process from you, right?
Yeah, it's honestly a lot less about the drafting than it is about the strategy. Once the strategy is properly articulated, the drafting becomes pretty straightforward, not boilerplate, but straightforward. And the strategy includes, all those different issues we talked about, whether it's a blended family, same sex, real estate, et cetera. They all come to bear. And, do you have a beneficiary, for instance, who has a substance issue? And we want to make sure that money that goes to them isn't wasted. There's just a lot of moving parts in drafting and in creating a trust, the strategy for a good, effective estate plan.
To that moving parts question, what are the critical elements that make for a comprehensive and effective real estate plan, particularly for clients with particularly complex assets or family dynamics?
It's getting very clear on what the intentions of the trustors are and how they should be best implemented. It's a who gets what and what about this person. And the other thing that I'm going to segue for just a moment, if you'll allow me, is people do care about what happens to their stuff at the end of their life, but they also care a lot about the quality of their life. And one of the issues we see is that people need to have a power of attorney for healthcare purposes, a power of attorney for financial purposes, and who they give that power to and what powers are enumerated can be extremely important. I can go off a little bit on the path and tell you that Sometimes we have clients that really are going to find themselves in need of a skilled nursing facility. And at least in California, the cost of that is extremely high, approaching $11,000 a month. On the other hand, we have a fairly generous Medi-Cal program in California, which recently has been very much liberalized. So many people can qualify for that. But even those that can't, we have tools to make it so they can.
What are some of those common complexities? Because it is true, we are seeing an aging population and a lot of these issues coming up quite frequently, more so than before.
Yeah, the requirement for either a skilled nursing facility, in-home services, all those sorts of things need to be planned for in your estate plan, not just the money part of it, who's going to pay for it, or how is it going to get paid, but also who's going to do that, who gets to make those decisions. So for instance, in your healthcare power of attorney, one of the things that we want to make clear is when a person does pass, what are their desires? What do they want to have happen at that point? And you need someone who is intimately familiar with those desires in order to be able to be in a position to make that decision on their behalf. The other thing in terms of healthcare power of attorney that I run into, I always counsel folks that if you're giving power to someone for financial reasons, or that it's best to have a single person so that you don't have conflict between two individuals over that. But when it comes to your healthcare power of attorney, better to give that to multiple people, because you don't want one person to be in the position of saying, oh, well, you killed dad or you killed mom or whoever it is, because they made that decision on their own without consulting with others. So again, there's strategy involved in that, in who gets what power and at what time. Most of the powers of attorney that we create are called springing powers of attorney. So they don't come into effect until the individual either can't or won't make decisions on their own behalf.
That's interesting what you're saying in terms of the healthcare decisions. So when you give it to multiple people, what are the logistics of that? I guess it's just a voting system, or how does that work?
Yeah, they actually need to come to some kind of a consensus between themselves. I mean, there is a remedy if they don't, and if there's a stalemate, then you're back in the requirement of going to a court and getting a judge to make a decision. But most families do not want that. Even the people that are given the power to make a decision don't want that. And so they will work hard to come up with an agreement that they can all live with.
Interesting. So as an LGBT-owned firm, can you discuss some of the common challenges faced by LGBTQ individuals when it comes to real estate planning, and how your firm addresses these needs in a unique way?
Sure. And I'll expand it. It's not really just real estate planning. It is estate planning. Mm-hmm. And that covers a world of possibilities, including your retirement accounts, including any investment accounts, including any collectibles that you have. And for many people, their net worth primarily is in real estate, but not for everyone. And a lot of people have other types of investments, either stock accounts or collectible artwork, things like that. And all of that needs to be addressed inside your estate plan. So with respect to answer your question directly, with respect to the LGBT community, then there are unique needs so that someone doesn't get cut out. And probably the best illustration of that is to tell a very short story. I was approached by a fellow who had been partnered with a man for 30 years. His partner became terminally ill. They went to an attorney. They drafted a trust. In the trust, the ill partner left the house that they'd been living in for years, left that to his succeeding or successor partner. But he made his brother the power of attorney for financial affairs. The brother had never approved of the lifestyle. And the brother went in once the ill person became incompetent, used that power of attorney, rewrote the trust, and wrote the partner out. That's the sort of thing that we're always keeping our eyes open for, to make sure that the wishes of both the trustors are carried out. And
how can you prevent those scenarios where someone's wishes aren't held up, I guess? How do you draft and plan for that?
That's a great question. It's partly a matter of strategy and partly a matter of drafting. So in terms of strategy, you first have to understand that there is this potential. and that be able to deal with the potential for a conflict with a surviving family member. And then the second part of that is to actually draft so that that potential disputing person doesn't have the power to make that change, or doesn't have the power to make that change individually. It would have to be made collectively. Sometimes it's even a matter of gifting a portion of a property or assigning a property prior to death, but generally I do not recommend that. It has typically adverse tax consequences. So again, it has to be really thought through.
What are the emerging trends you see in estate law right now? And what should people be most aware of? Obviously, there's a lot of different things to be considerate of.
Well, this may sound self-serving, and it is, frankly, but one of the trends I'm seeing is that people are trying to do it yourself. Yeah. And they're trying to avoid fees for attorneys. And some attorneys are egregious in what they're charging for this service, but it doesn't have to be that way. And in the long run, the do-it-yourself ends up costing the beneficiaries and sometimes even the trustor more than it would have than to do it right in the first place. So there's ways to go about that. But as an example, I've had people say, well, I'm just going to transfer the house now. One of the great benefits of a trust is that your home in that trust gets what the IRS calls a stepped up basis at the time of your passing. My example of that is if you bought a house years ago and you paid $50,000 for it. Yes, there was a time when you could buy a house for $50,000.
What?
And
what world are you referring to?
Yeah, really. And today that house is worth $800,000. If that property is, if there's a no will or trust, even if there is a will, it doesn't get a stepped up basis. And that means the beneficiaries are going to pay capital gains tax on the difference between the $50,000 acquisition price and the $800,000 sales price. That could be $250,000. If it's in a trust, the basis gets stepped up to $800,000 upon your death, and then there's no tax due at all from a capital gains perspective. And that's the kind of mistake that I see that folks do when they're trying to do it on their own.
Seems like, so at its core, it's really not understanding those legal nuances. They can maybe create a serviceable contract of sorts or a deal, but they're really not going to be able to optimally represent themselves.
Yeah. And, again, the trade-off is remarkably advantageous to the trustor and the beneficiary. The cost of creating a trust is modest in most cases, and the cost of not doing it right can be enormous. Yeah. And so it's certainly worthwhile at least get a consult and find out what you don't know. I mean, and that is the challenge with all of us in all our different domains of life is you don't know what you don't know. And you go to an expert to find the answer to that question.
Richard, can you tell us a little bit more about multi-tiered MAP Act land splits? It's a little bit of a mouthful.
It certainly is. And if you're working with developers, you can run into that. It's a process by which somebody buys a piece of property, a parcel, and splits it into 4 or more pieces. And 4 is the magic number in California because you can usually do that without doing what's called a pink. Larger splits than that require more work, more engineering, more survey work. But each time you transfer property in that context, you have to be careful about how that property is held and how it is transferred so that any benefit from a trust is not inadvertently eradicated.
Richard, can you walk us through some of the important legal considerations when it comes to state and federal courts throughout California as it pertains to estate disputes? Sure.
There's a lot that rides on what court you select or what court you can select to resolve a dispute. Hopefully, with a well-drafted estate plan, you don't end up in court. That's the whole point, is to avoid that. But there are times when you do because of drafting issues or contentious parties. I do have a saying that when someone passes, it brings out the greedy, grubby group. And even in the best of families, it's pretty amazing how people can get on each other about who gets what. But in terms of courts, most real estate related issues are going to be resolved in state court because state courts have primary jurisdiction over real estate. But there are instances where other aspects of federal law are invoked. And although it was not an estate related matter, I had a case recently where we specifically took that case to federal court because we had the grounds to do so, because I knew that the opponent didn't want to go there. And most attorneys are apprehensive about going into federal court. I've been there a bunch of times, and it's just another court with a lot more stringent rules than most state courts have. And so it can make a big difference in choosing that particular venue to have your issue litigated.
How often do cases actually end up in court, either state or federal?
That's a great question. I'll answer that in terms of estate-related issues. And I'll ignore probate, because probate by definition goes to court. But how often do intestate cases, more particularly, how often do estate plans go to court? I would say probably less than 10% of the cases actually get litigated. And usually it's when there's a lot at stake in terms of resources. Not always. Sometimes it's about individual items that people want to get. But more often than not, it's because there's a lot of money at stake.
And how do you coach your clients when you actually do have to go to court?
Well, the first point is avoid it at all costs. So if you need to compromise somehow and settle the case, by all means do that. That is the most cost-effective thing. As an attorney, I'm not a fan of litigation. It's a giant sinkhole for money. I'm ready, willing, and able to do it, and happy to serve in that regard. But it is not typically the best solution. It's much better to engage. For instance, sometimes we go to a mediation where we get an independent party. It's non-binding, and that person meets with each side or all sides, depending on how many are involved, and attempts to come up with a resolution by hammering on every party and say, here's what you've got to lose, here's what you've got to gain, and trying to find that middle ground. It's a little bit like diplomacy and going from country to country. That's what this mediator, that's what their job is. And my definition, it's not unique to me, of a good settlement is that the parties all come away equally unhappy.
I think that's sort of the classic, what they said with the Constitution and what we say in a lot of diplomacy as well. Everyone kind of leaves a little bit unhappy, but they got some of what they wanted. So as we're bouncing around a little bit here, I want to ask you about some strategies or advice for individuals and families looking to minimize estate taxes, but maximize the preservation and distribution of assets.
There's actually a couple things to think about. It's taxes when the property passes, but taxes also as you go through life. And there's also the exposure to liability. So one of the fine things about having an estate plan is, at least in the estate plans that I draft, we have what's called a spendthrift clause, and that prevents creditors, for the most part, all creditors, with some exception for IRS, of getting to any of the assets of the trust. It also prevents one of your beneficiaries from hypothecating or borrowing against that. So that's one aspect of it. But another one is, frequently we will have people who have rental income put that rental income into an LLC and then assign the ownership of that LLC into their trust. And that gives them additional levels of protection and minimizes any kind of tax. So if you have a transfer, in an LLC, I'm going to back up a minute. In LLC, typically we elect what's called the S-corp treatment, so that any gain or loss from a property passes through directly onto your 1040. And that's typically a much better rate for you than the corporate rate. And then by putting that into an estate plan or a trust, it doesn't change that. That still passes through as long as you have, and I know we haven't talked about revocable versus irrevocable yet, but as long as you have a revocable trust, then the income on that trust is going to pass through to your 1040 anyway. So you're getting the best bang for the buck, and the property in the LLC has much greater ability to deduct the expenses associated with it than you would, for instance, on a Schedule E on your personal return. So the impact of the money that you spend maintaining your property or improving your property that's a rental property inures to your benefit.
When someone's forming an LLC, how do they differentiate between which actions are taken under the LLC and which, renting, et cetera, and what's the individual? How do you make distinctions between the two?
Generally, you're going to form an LLC and put property into it. You're going to deed it into it. So it'll be the XYZ LLC that owns this property at 1234 Lincoln, for instance. And any expense that's associated with the maintenance or improvement of that property, insuring it, any professional services, legal services, tax services, consulting services, all those are going to be legitimately deducted expenses on that LLC. Whereas they may run into some problems trying to deduct those things on a Schedule E and on a 1040, for instance. So I think did that answer your question?
Yeah, no, that's helpful. It's helpful to kind of get that insight. So, as we sort of begin to wrap up here, I want to ask you what brought you into estate law, what motivates you, what inspires you. We talked to a lot of different attorneys and lawyers from different areas. This is definitely an interesting one.
Yeah, it's interesting. I've had so many horror stories from friends and family that things just went completely sideways. They got stuck in litigation that went for 2 or 3 years, or they ended up in a probate that took 3 years and cost them a lot of money because probate's far more expensive than a trust is. That I didn't want to see those folks have that problem. That's kind of sent me down that path. And the more I've gotten into it, and particularly in the LGBT market, I see how badly people can be hurt after a lifetime of work. Either their savings or investments are gone because it didn't get handled right, or the intended beneficiaries don't get it because somebody outwits them. And so really, in essence, I'm a Rotarian, and I like to put service above self. And I like to look at what benefits my clients. The name of my firm, as you may have noticed, is Bottom Line. And that's because I'm oriented to, what is your bottom line? How do I get you what you need and want as cost effectively as possible? And that's another part of dealing with estate planning. Doing it now instead of doing it after the fact with probate is far more cost effective for folks.
Is there still a lot you can do after the fact, or is that kind of tough?
Well, there is sometimes. So for instance, we have a process where if a property, a piece of real estate, was not put in the trust. And when I say put in the trust, I mean it was deeded to the trust. So if you owned a piece of property, Matt, there'd have to be a grant deed that says, I, Matt, give this property to Matt as trustee of the XYZ trust. And that needs to be recorded in the county recorder's office. That's what puts it in the trust. Non-real property can be transferred by means of the pour over will, though it's not essential. But the intention of having the real estate in needs to be expressed by a deed. Sometimes that hasn't happened. But if it's written in the trust that it was the trustor's intent to include that in the trust, then I can go into court with what's called a Hagstead motion and petition the court and ask them to include it in the trust. And normally that's successful, but it depends upon how clear the intention of the trustor was that they wanted to be in the trust.
So Richard, I think we've covered a lot of different interesting angles, many different dimensions to consider here. For listeners, if you had one key takeaway, what would that be? Don't
wait on a estate plan. I like to say, you remember back in 2008 when we were having the real estate loan debacle, they used to say if you could fog a mirror, you could get a loan. Well, I've adapted that. See, if you can fog a mirror and you're over 18, get an estate plan.
I think that's some sound advice. To wrap it up, thanks everyone for listening to Inheritance Solutions for a Diverse Community. For more information, find Richard Hall on social media and visit bottomlinelawyers.com. Richard, thanks so much for your time today.
Thank you, Matt.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.